Okay, good morning. Everybody hear me?
Good morning, Your Honor. Coming in loud and clear.
Good deal. All right, it's 9 o'clock. It's Thursday, May 16, 2024. Welcome to a Zoom oral argument session of the 5th District Court of Appeal. I am Judge Lambert. I'll be presiding on this one case that we have this morning. Joining me on the panel today are Judges Eisnagel and Pratt. You can see them in their respective boxes there. We have one case on the docket today. It's case 23-1538, which is also consolidated with case 23-1539. The 1538 is Raymond Moyer, Robin Collier Moyer, and William Glenn Roy Jr. Esquire versus All One Pools Inc. All One Pools LLC, William Wallace. Assume he's not from the Braveheart fame. Stephen Geiger, Wendy Geiger, Billy Blevins, Kelly Hunter, and Paul Marks are all names listed as appellees for various reasons. All right. You'll see in the upper left corner, at least on my screen, we have 20 minutes per side for the oral argument. There probably is a 5-minute default time for the rebuttal time for the appellant. For the appellants, Mr. Shaneen, if you'd like other than 5 minutes, let us know, and the marshal will adjust the clock accordingly. When you get into your rebuttal time, the yellow light will come on, start flashing. I'll keep a heads up for you, let you know. You obviously can continue on as long as you want. You don't necessarily have to stop with 5 minutes to go, but you don't have any more than 20 minutes in the aggregate. We are being live streamed on YouTube, so our vast audience is watching this morning. So please, if you have any phones or any other electronic devices, please put them on mute, or at least turn them off so they don't disturb either the counsel or the court. That said, if you're ready to go, Mr. Shaneen, go ahead.
Thank you, Your Honor. Mr. Marshall, if you could adjust my clock for 6 minutes, I would appreciate that. Thank you. May it please the court. My name is Nick Shaneen, the Shaneen Law Firm, and together with C. Andrew Roy of Winder Weedle Haynes, we represent C. Glenn Roy Esquire, Glenn Roy Jr. Esquire, and the Moyers, his former clients. This is an interesting case about, at its core, ethics and the ramifications that happen if a decision is made that doesn't comport with the facts of the law, resulting in a unintended divorce of an attorney from his clients. Nothing is more important to the administration of our judicial system than the ethical.
Counsel, why was that order a final order? Isn't that important for your argument?
It is asterisk. The asterisk being that there are alternate methods by which this court has jurisdiction if it wishes. But it is important for the argument that the order was final. And the answer is it was final, at least as to Attorney Roy. Attorney Roy, there was no further judicial labor.
Mr. Shaneen, just one point that I'm not totally clear on, maybe you can help me out, is how did Attorney Roy become a party to this case? Did he have a motion to intervene, a motion to substitute party? I understand that he was acting as counsel at one time in the case, but if you could explain how he's a party to the case, that would assist.
Certainly. That at no point did Attorney Roy actually become a party to this case. Let's be clear about that. He is a non-party, but non-parties have rights. Just as the witness had rights and A Few Good Men, non-parties have rights. And those rights can result in an order that affects a non-party. And the case law of this district and all the others are replete with cases where non-parties have standing before this court to appeal an order that may not be final as to any of the actual named parties, but it's absolutely final as to them. Insurers often stand in that position if they get identified in an order to do this or do that. A witness might be compelled to do an action, and an attorney is certainly subject to being something within an order. And the case law is clear that where an attorney is subject to an order, that order may be appealed as a final order. And so that's why.
Well, let me ask, so is it your position then, if the Moyers themselves, the actual parties, did not want to pursue an appeal of the order denying the 1.540 motion, that Mr. Roy could independently pursue relief on his own as the aggrieved attorney, and we would have jurisdiction to hear? I mean, let's take for the purpose
Sure.
of the argument, it's a final order. I'm not convinced of that, but for the purpose of the argument, or my question, if it's a final order, why can he pursue it as the unhappy lawyer when the parties who have the right under the rule to appeal under 1540, an adverse order, do not?
So, Your Honor, to answer the question first, let me make clear that it is a pure hypothetical, because in this instance, the Moyers absolutely wish to retain Mr. Roy as their attorney, wish to have Mr. Roy continue as their attorney, to this day would like Mr. Roy to be their attorney. So they are absolutely, they've hired me. They want me to pursue this appeal. So this is a hypothetical. But to the extent that Mr. Roy is separate from his clients, he would have had he could invoke the jurisdiction of the court, but there's an asterisk on this one. I've already put in one asterisk. Here's a second. And it goes to this. In this instance, where the nature of the order was an order disqualifying Mr. Roy, if his clients do not wish to appeal that order because it's a disqualifying order and not, say, a sanction order imposing a monetary sanction upon Mr. Roy, in that instance, the wheels would come off the bus if the Moyers did not also wish to pursue that, because the whole nature of an attorney-client relationship is that the clients wish to have that attorney stay on as their attorney.
But I mean, they may decide they don't want to spend the money anymore on an appeal, and they say, well, we can go get the lawyer down the street and do it, and we might not like what the judge did, but, you know, que sera, sera, we're moving forward with attorney B. Mr. Roy, I think you've answered the question. He's not been held in contempt. He doesn't have to pay any money. He's just unhappy he's been removed. He thinks it's wrong. But absent the Moyers joining the train, he really don't have a right to pursue this here.
It would be much more difficult. The one I'll throw a third asterisk in here, that this order disqualifying him also contained a referral to the bar, also contained information that was directly damaging to the attorney.
So a referral to the bar is appealable?
A referral to the bar would not be appealable in this court, because the referral to the bar is its own avenue. So I'm not trying to create a new jurisdictional avenue for this court. But what I am suggesting is that the order itself was more than the disqualification has an existence that goes beyond merely the unintended, unwanted, involuntary severance of an attorney from his clients. And that's
the 1.540 motion and whether it was authorized is an interesting question, right? So on the question of whether the underlying order was final or not, walk us through that. And does 9.130 give us any hints as to whether that order is final or not?
Well, and on that, I'm going to say this: 9130 is an interestingly titled rule. It used to be simply the appeals of specified non-final orders. And the late, great John Hamilton was part of the Appellate Rules Committee and had that renamed to include the phrase "and specific final orders." And the reason for that is exactly 1540. That 1540, depending on whether it's granted or denied, can result in a non-final order if it's granted, because then there will be judicial labor to follow, or it could actually be a final order because there is no further judicial labor to be done. But because it is a special final order, they have included it in the ambit of Rule 9.130 because it acts like an interlocutory order. And so that's where it's classified. So
well, you might, I mean, look, I concede that the title now says specified final orders, and there are probably some certain circumstances, but 3, which is what we would fall under, doesn't say anything about specified final orders. It says appeals to the district courts of appeal of non-final orders are limited to those that.
That is true, Your Honor, except I believe that the 1540 is actually not 3, it's 5. 9130A5.
Right. No. I think we're missing each other. I'm talking about the underlying order. The order.
Okay.
Yeah. Yeah, I'm talking about the underlying order. So 3E,
Right.
why does that not sort of give us an indication as to whether that underlying order, and I apologize, it sounds like we were talking about two different orders the entire time.
Not and
So
I
the,
get it. And certainly 9130A3E, which is specific to the opportunity to appeal an order granting or denying disqualification.
Granting a motion, granting a
that
motion to disqualify,
that
of which
that is,
there is none here.
well, that is an interpretation. I would
That's what the rule says, isn't it?
I agree, Your Honor,
Right.
and I am a textualist, so I agree with looking at the words, and words matter. That said, to parse a order that is the result of a motion by a party and an order that is the result of essentially the court's own motion, a sua sponte order to show cause is the motion of the court.
counsel, let's take that but let's assume that for a moment. I'm not sure I agree with you, but let's assume that for a moment. Either way, doesn't this rule suggest that it's a non-final order?
That does suggest that that's the remedy for that, but it doesn't.
No, hold on. Doesn't it suggest that it's a non-final order as opposed to a final order? Yes or no?
That's a correct
Okay.
statement. Yes, Your Honor.
So how would your order, whether it was a motion or not, how would your order, the underlying order, be a final order? The order of disqualification, how is that a final order?
I would direct the court to the 4th District Court of Appeals, Shook versus Alter, when a final order is enacted on a non-party, such as an attorney, that order is appealable as a final order.
Was that a disqualification order?
That was a sanction order against that.
Well, that might be different, right, than a disqualification order.
Well, and it seems to me illogical that an order affecting an attorney would be differentially treated if it's a disqualification versus some other appropriate.
Well, a sanction against a lawyer is a direct problem for the lawyer. The lawyer has a direct interest then, right? Hey, pay this money, lawyer. They have a direct interest. When a lawyer is disqualified, I think we've already established that the right lies with the client, not with the lawyer. That's a different issue, I think.
It's at least related. That it is a nuanced question of whether or not we look at Shook v. Alter and the other cases that we've cited in our briefing similar to that case, where attorneys have been able to appeal orders that directly affect them. And I guess that's where I'm going to go back to the issue of this order and the way it was created. Definitely created a circumstance for Attorney Roy that if the truth will out, if there's going to be a method by which he can vindicate his good name and find a way to put before the court the events that actually occurred, then the disqualification order has become something more than a simple look. Your clients will be fine. They can find another attorney. They had rights. He has rights. And while the rights as to the client is certainly a non-final order, based on
Counsel,
the same principles.
Generically, I understand your argument in a generic sense. And look, absent the rule here, I think your argument would have at least some legs. I'm not sure what I would think of it, but tell me how we would write the opinion. If we went with you, right, your direction, sure, in a way that didn't really substantially conflict with this rule 3E.
So the way that this court could write the opinion is to elect not to, well, one, it could look at 3E for purposes of the lawyer, but that's not what we're talking about here. Instead, this court's opinion would simply say that while this order would be otherwise appealable as a non-final order pursuant to this rule, the subject sanction or effect upon the attorney was such that This court treats it as a final order reviewable under 9100.
But other than disqualification, I mean, obviously disqualification wouldn't be enough because it's not enough under 3E, right? So
Well,
what is it that we would point to?
I will also, put before the court that 3E is a relatively recent development in 9130's jurisprudence. So Shook v. Alter and that line of cases preceded 3E. I don't believe it was the intention of the rules drafters to pull away that just because one door opens doesn't mean the window shuts behind it. It is possible.
Well, you agree that an order disqualifying counsel cannot be both non-final and final. That's not possible, right?
I am not sure that I'm going to agree with that.
All things being equal, you are disqualified, counsel. The end.
Right.
That cannot be both final and non-final.
Well, in a way, it is. It is
Okay.
intrinsically a non-final order as to the party, and it can be deemed a final order as to the attorney. Normally, an attorney.
But we've already established the attorney doesn't have a right to pursue it by themselves. This is the client's right.
Well, and I agreed with that in principle, except only because the attorney-client relationship doesn't work without the parties agreeing to it. But if the parties were to be in Judge Lambert's hypothetical, we agree with it. We countenance it. We support you, Attorney Roy, but we're not going to buy it. We're not going to pay for the appeal. So you appeal it on your own.
So, Mr. Shaneen, if we could just back up and look at the 30,000-foot view, and
Sure.
Just kind of borrowing off of Judge Eisnagel's question, assume we disagree with you.
Okay.
And we think that the three bases of jurisdiction that you are asserting are mutually exclusive.
Okay.
We can't pick both, can't pick all three. We have to pick one.
Sure.
Let's further assume that we agree with you that the analysis could be different for Attorney Roy and then for the parties. Okay.
Sure.
In your view, which is the strongest basis for jurisdiction as to Attorney Roy, and which is the strongest basis for jurisdiction as to the parties?
Thank you, Your Honor. I would sum up, as I see that I have gone deep into my rebuttal, that it is 9100, a final order, is the strongest means by which Attorney Roy can attach jurisdiction to this court. And at the same time, it is the non-final path / certiorari by which the aggrieved clients would have before this court for their remedy. And with that, I would like to save the rest of my time.
Well, let me ask, I'll give you a little bit more. Let me ask you one more
Yeah.
question. In the 2021 proceeding, the one was converted to assert.
Right.
If we had entered the order and that denying it and had used the words on the merits or with prejudice as opposed to citing to tops, I'm gleaning from our discussion today, we wouldn't be having a discussion today.
You are 100% correct, Your Honor.
Okay,
we
that's
respect what on the merits means, and we respected what the court meant when it said tops v. state. So with that,
Okay.
Thank you, Your Honor.
All right, very well. There's your good. Okay, Mr. Vidoni, good, ready to go?
Yes, I am. Thank you, Your Honor. And may it please the court, I'm Nick Vidoni. I'm here on behalf of the appellees. I think the case, it lacks jurisdiction for the reasons stated in Garcia. Essentially, once you have a non-final order, which I think this is, and we'll get into the nitty-gritty of that, but once you have a non-final order, you can't file a motion to vacate a non-final order and then appeal the denial of that motion to vacate. Essentially, Florida Rule of Procedure 1.540B applies to motions to vacate judgments and final orders. It's not really geared towards non-final orders. The reason for that is there's already a pre-existing mechanism to reverse non-final orders, and that's through motions for reconsideration. The judge has the power to reconsider non-final orders at any time and amend them. So there's no real need for the appellate court to get involved until those non-final orders essentially get locked in through some sort of final order, and then you have the right to appeal.
So, Mr. Vidoni, can we back up just a second? I want to ask you the same question that I asked your friend on the other side, which is how Attorney Roy is a party on appeal. Do you agree with your friend on the other side that even understanding the fact that Attorney Roy was not a party below, that he can be a party on appeal asserting his own rights? Or do you disagree with that proposition? Just putting aside any potential jurisdictional defects, just the basic question of who are the parties to this case on appeal?
Yeah, I agree, but for different reasons. So the court has inherent jurisdiction over the parties that are served, and then they have inherent jurisdiction over the attorneys that are before the court. Essentially, the attorneys kind of become agents of the parties by way of their relationship, and according to Florida bar rules, bad things can happen to an attorney in the case, and they don't need to be served with a subpoena or anything for the court to have jurisdiction over them. So I think that an attorney can be a party to appeal based on that relationship. So I'm not contesting whether they can be a party to the appeal. I don't think that.
Well, if they're sanctioned, if they're looking at contempt sanctions or they're fined or something, and they think it was some erroneous, matter of law or some abuse of discretion or evidence to support it. I mean, how is it if you get disqualified, that becomes you as a right, you have a right as a, you have standing, I guess, to pursue an appeal, even though you're not a party as the attorney.
Well, I think with the disqualification, it is somewhat of a tricky issue on that. Disqualification, certainly there are financial repercussions to an attorney not being able to receive payment from their client anymore. But I do agree with the court that with disqualification, really the person in the driver's seat should be the client. And they're the ones that really have the right to make determinations as to should I appeal this or not.
So are you saying then if the Moyers here didn't want to appeal this, they said, we're going to use our money in other directions. We have an arbitration coming up. We don't want to appeal this anymore. But Mr. Roy wants to appeal it because he's personally aggrieved by being removed from the case, that he has the right to pursue an appeal here of that order?
I mean, if there are certainly monetary sanctions, yeah. So just disqualification.
But he's not been monetary. There's no monetary here. I'm not making a hypothetical. There's no monetary sanction. It's just you have been removed. You're out. They can get another lawyer. They got 60 days to get another lawyer.
Yeah, I don't think he has standing to do it. There hasn't been a clear case on the point, so I think he can make an arguable case in the lack of authority either way to make arguments why he should be here. And I think
you're cheering up Mr. Shaneen here, I think. So.
Yeah, my agreement is substantively different. I mean, I don't really care whether Mr. Roy is a party to the appeal or not. This court, I know, deals with those issues and probably takes those issues more seriously. My main beef is the issues concerning jurisdiction when we have a non-final order that was entered. I think it's clear that
well, counsel, I mean, opposing counsel sort of is tying all of these things together into one bundle and suggesting that, well, an attorney has rights to represent someone, and because they have rights to represent someone, an order of disqualification is final for purposes of that attorney. Although he then says, and I'm not sure I follow this or agree with it, but he then says, but it's non-final as to the parties. I think that's essentially one of the positions he's taken. So it could be relevant, right? Whether, at least for argument today, if the attorney has his or her own rights to represent a client.
Yeah, and I will note that these issues were raised in the previous appeal, that they were rejected by the court. And so I think that brings us to the law of the case, which infects just about every issue in this appeal.
I mean, we cited Tops. How does that, going back and reading Tops, how does that indicate that we reached to the merits?
Yeah, Tops basically says, wait till you have a final appeal, then come knocking on our door. So I think the issue is that we don't have a final order, which is basically what TOPS requires. So,
Right. I mean, clearly we decided, a different panel decided previously that this was a not that the order of disqualification was a non-final order. That's what it looks like, right? It looks like they decided that, but the question becomes, is that now binding on us now?
I think it is. I mean, I know Judge Lambert was in that panel, so I mean, yeah, I guess he can change his mind, but I do think there's a problem when the one panel conflicts with another panel. It really interferes with the court's legitimacy if essentially results are dictated based on what the panel is.
Well, what happened in the other case is the notice of appeal said, we're appealing this as a final order, but if you don't like, I'll use his let's make a deal analogy. If you don't like that, we're going to also challenge it as a non-final order under 9130A3E, the disqualification of the attorney. And then the motions panel, I was not on that, decided to convert it to a cert petition. And then I was on the merits panel of the cert petition. And that's when we denied it with a citation to TOPS, which is we're discussing here, as Mr. Shaneen pointed out in his briefing, that wasn't a determination on the merits. In fact, it's the opposite. It's basically because we didn't say denied on the merits and cited to TOPS. It proceeds forward, and that's why we're now here on round 2, I guess, for lack of a better term.
Yes, and I think there's a problem with the.
So it's not law of the case, in other words.
Well, it's law of the case in the sense that the court, what you call the motion panel, decided that this was a non-final order, the disqualification order. I don't think that we get to relitigate that after it was determined by this court that there was a non-final order. The citation to TOPS, again, all that says is, now's not your time to appeal. Wait till you have a final order, then, we can take it up. I think the way you get to that is.
So you're saying there's a difference. You're saying there's a difference between reaching the merits versus the vehicle we used to analyze it to begin with. The vehicle being final appeal, non-final appeal, or cert. And then once we've chosen a vehicle, then do we reach the merits of the case? Is that what you're saying? There's a difference between those two?
I'm not exactly sure I understand the question. I mean, the vehicle.
Well, you're saying that you admit that we didn't reach the merits, right? Cite to TOPS. It looks like we didn't reach the merits there, correct?
Didn't reach the merits as to the arguments. I think they reached the merits as to whether it was a non-final order. Okay.
Well, that's what I'm trying to say, is that it looks like the merits of the case, right? Whether we decide whether we review it as a final order or non-final order or cert on appeal, is that the merits of the case?
Well, I mean, certainly certiorari sometimes involves a question of the merits, but you need to go over certain hurdles first. You need to show the certiorari jurisdiction of irreparable harm that cannot be corrected on a post-judgment appeal. And then once you show that.
So if we say we're reviewing this in cert, we have not necessarily yet reached the merits just because we've decided that we're reviewing it via cert, correct?
If you're talking about the present case?
No, well, I'm talking about the prior case. The merits of the appeal, the prior appeal, we agree we didn't reach the merits. I think we all agree on that.
Yes. So, I mean, the previous
but
case.
We also agree that we did previously decide that it was reviewable via cert, correct?
I don't know if the court decided that it was reviewable via cert. I think that there's certainly some discretion of the court when it proceeds via cert.
Well, counsel, it was converted to us. I mean, it was not filed as a cert petition, right? Yeah. It was not filed, and it was converted by the motions panel to a cert proceeding. And then a cert's an extraordinary writ. So what Judge Eisnagel is getting to with you is, it's not a merits determination. I mean, you made a court may decide because it's extraordinary writ that it's not something that cert relief should be appropriate for whatever reasons, especially in an unelaborated order.
Yes.
So that's behind us now. So now we're here on a non-cert proceeding here, and we're trying.
Well, I mean,
go ahead.
One of the arguments is that by the appellants is that the court should consider this a cert proceeding and review it as a essentially second petition for cert. I think the court can't do that because you don't have a right to a second petition for cert on the same issue. In my appellate brief, I cite all the cases, including Ever versus Lawfer. Essentially, you don't get to relitigate the same issues and using 1.540B, but also you don't get to relitigate the same issues on cert. It becomes a waste of judicial resources. The citation adopts in the previous case clearly identified that you wait till you have your final order, then come knocking on our door. So I think there's two ways you get in a final order. One is you have some sort of final order confirming the arbitration awards, which did just recently happen this month. And I think that there are questions of mootness related to that. And then the other way you get a final order is the court reserves jurisdiction to award sanctions in terms of a monetary sanction. So,
so counsel, going back to the prior issue that we were trying to figure out, we determined previously looks like we determined that the order on disqualification was a non-final order. We treated it as a petition, right? And then we declined to reach the merits. Do you agree with that sort of summary of the prior appellate proceeding?
yes.
Okay. So it sounds like to me, your argument is, hey, look, yes, the court didn't reach the merits previously because we cited tops, but we did decide that the order was non-final and therefore treated it as a petition. It sounds like your argument is we are bound by that prior determination that the order on disqualification was a non-final order.
Yes, and in addition to that, the court is bound by the previous panel's determination that certiorari is not appropriate for these issues. So you can't.
Well, that's a bigger mountain to climb, right? Why don't you walk me through why we're bound by the prior panel's determination that the order on disqualification was non-final? Because that seems important now.
Yeah, so the law of the case issue really deals with was the issue litigated and the court make a determination on that issue. And I think when you look at what happened in the prior appeal, this court said, hey, we don't think that this is a final order. Go give us briefing as to whether this is a final order. That was briefed, argued, litigated, and then this court made a determination on that issue. So it was litigated, argued, and the court reached a decision. So that's all you really need for the law of the case to apply. And then, we move on to, okay, now that has been established
in other words, the fact that we then didn't decide that there was a departure from the essential requirements of law doesn't necessarily negate the binding effect of our prior determination that the order itself was non-final.
Yes, correct. So, I think throughout this issue with regard to all the jurisdictional issues, there was, I think the citation to certiorari jurisdiction. I think this court can't entertain certiorari jurisdiction because the previous panel didn't. If we deal with 9.130A5, that's supposed to be for orders entered on an authorized and timely motion for relief from judgment. I think you fall into the problem of the Garcia case, Garcia versus Navy Federal, where this court said that doesn't give you the right to appeal motions to vacate a non-final order. We already have law of the case applying the factual determination that that order was non-final, so you don't have jurisdiction under that rule. And then we have 9.130A subsection 3 subsection E, which is orders granting or denying a motion to disqualify counsel. And I think the key word there for here is that it needs to be a motion. Certainly, if there were jurisdiction to disqualify counsel on the court's action without a motion, the Florida Supreme Court has the power to add that. They change the rules all the time.
Well, counsel, let me ask this from a pragmatic or using Judge Pratt's 30,000-foot view. How do these guys appeal this order? Let's say it was wrong back in the trial judge sua sponte issued this order to show cause. He had his hearing, says, all right, bad stuff, Mr. Roy, you're out. Order, you're disqualified. Get new counsel. And let's say the Moyers and Mr. Roy collectively, maybe more so the Moyers, are really unhappy about that. It's not the result of a motion to disqualify. How do they challenge, or when do they challenge it?
I think you have a avenue to challenge it through certiorari, which they already did, and the court denied that. And then you have the opportunity to challenge it when there's a final order, such as the order confirming the arbitration and providing a judgment. And then you also have the, in this case, an order saying yes or no to award attorney's fees as a sanction.
So there, after the referral to arbitration, so at some point a judge will enter a final order confirming or not confirming the arbitration award, and that's when you're saying after that point they can appeal and they could challenge this order back in October of 2011.
Yeah, I mean, that I will give a caveat to that, because there are statutory ways to challenge an arbitration award. I don't know if you can.
Do you do it in the same case?
I don't
in the pending case, or do you have to file a separate action to enforce the arbitration award?
Well,
Confirm it, excuse me.
It depends on how everything, well, you would do it in the same case, because once the case, and in this case, you have a referral to arbitration, and once the arbitration is done, which has happened,
so our arbitration sort of muddied the waters for the purpose of our discussion. In other words, if there was no arbitration here, if the judge had simply entered the order saying, Mr. Roy, you're out, and the case proceeded to a trial, whether it's a jury or non-jury, and then a judgment was entered, then whoever was, I guess it would be the Moyers side, if they were unhappy, they can say, we're going to raise these issues on appeal, one of which being, you shouldn't have disqualified my lawyer 3 years ago.
Yeah.
Then it would be a final appealable thing, and that'd be one of the issues we talk about.
Yeah, I think it would be final appealable. I think I haven't really thought completely about all the nooks and crannies of that. I think there would be issues as to whether that, if, for example, if the appellants in this case won at that trial, can they go and appeal when?
Well, why would they if they won?
Yeah, that's the thing.
And they have to actually be the adverse part. I mean,
yeah. So that's wrinkle number one. The other wrinkle would be whether they need to show that the disqualification order had any sort of effect on the trial performance. That might be something that might.
But I mean, it would be appealable at that time. So I guess the question is, because it was referred to arbitration, and that eventually an arbitration would end, is that still? You have to wait to have a judge confirm or do something with the arbitration award, and then this 2011 order disqualifying Mr. Roy would be part of an appeal if the appellants were if they lost in the arbitration and they're unhappy.
Yeah, I mean, I think you need some sort of final order, and there's all sorts of non-final orders that aren't appealable. The whole reason we have that is to save judicial resources. The appellate court doesn't want to be sitting in a capacity nitpicking over every single ruling that a trial judge makes.
Of course, those non-final or appealable non-final orders are growing by the month, aren't they? It's up to Tallahassee, though. That's not our call.
But I mean, the ways the rules are set up is, certiorari jurisdiction is so limited. It's largely because the appellate court doesn't want to be bothered until the case has reached its conclusion. So
that's Mr. Shaneen's point, saying, okay, we did, it's very limited ability to get relief, and therefore the panel exercised their discretion back in 2022, I guess, not to do it. And so now we're past cert, we're here on non-final or final, and let's tee it up and see who wins. When else can I do it? I got kicked out in 2021 when I didn't want to go that route. Now I'm back again, and you guys are kicking me out again. It ain't right.
Yeah.
Kind of a Marion County kind of argument, I guess.
I think there is a problem, at least hypothetically speaking, about when can you appeal it. I think you can appeal it when the sanctions order becomes final, or when you have a final judgment of sorts. There are technical difficulties with that, but there are technical difficulties with the rulings on a lot of non-final orders. There are discovery orders that cause problems to the parties that may not be remedied on appeal. These are problems that if
all right, counsel, you're past your time here, so you want to just wrap it up, and I'll give Mr. Shaneen some more time.
I think the issue really is one for the Supreme Court to resolve through making rules. If they haven't done it, we can't go and make those out of plain cloth.
All right. So what you want us to affirm or dismiss or something?
I think that should be dismissed for lack of jurisdiction.
You want Judge Eisnagel to write an opinion, says Mr. Benoni's side wins.
Well, we do have a motion for attorney's fees. We have requested that, but we do want the case dismissed. We don't think that there's jurisdiction.
All right, thank you, counsel. All right, Mr. Shaneen, I guess we'll give you up to 6 minutes here, since I missed.
Thank you, Your Honor. I went into my rebuttal time, and now I've gained it back. So
there you go.
Well,
shrewd strategic move there.
No, the tactics I've got. So we talked about, you referenced my briefs reference to let's make a deal, and the three different choices that we have good faith basis and arguments for why this court could take any of those available avenues.
You and I are probably the only ones who knows what that means. That let's make a deal.
I appreciate my fellow hairstyled individuals knowing what I speak of there. I'll go to a slightly more recent vintage game show, and that would be Jeopardy. Because we already know the answer to this question if we can ever get it heard. And that is that, yes, the order below was error. And the Supreme Court decision of In re Decker makes it abundantly clear that there is no representation for purposes of another attorney's discussion with someone if that person consistently avows that they are unrepresented. So we know what the answer is, but the question is when do we get to appeal this? And Your Honor referenced that when we were discussing.
Counsel, give me your best argument, assuming that this court were to conclude that the underlying order on disqualification was non-final. Okay, and whether we conclude that we're just bound by the prior panel's determination, or if we conclude on our own that it is non-final. At that point, the underlying order on disqualification, how do we have jurisdiction?
So the hypothetical hamstrings such that it is difficult to give a good answer, but the answer would still be that this court in Moyer 1 told us not now, but it specifically said later. Now, my opposing counsel says later must mean after a final order, but we just discussed how a final order creates its own issues if we wait until the confirmation of an arbitration award. That
not every non-final order is realistically appealable, right? Would you agree with that?
Well, and that could be true, but when an order goes to the core of what we are doing as attorneys,
right? But I guess Well, I don't want your time to run out without this answer, because I think this answer is important, right? So if the underlying order on disqualification was non-final,
Right,
you filed your 1.540 motion, right?
right.
How do we have jurisdiction? Or maybe the answer is we don't. Maybe the answer is this is a critical point.
Okay, so to answer that, I believe, and I've argued consistently in the brief, and it was argued, to be honest, in Moyer 1 as well, that the order below was final as to Mr. Moyer, not Mr. Moyer, as to Attorney Roy. But here's the one interesting twist there, is that for reasons that were not elaborated, and that's why there is no law of the case to be attached to a motions panel decision in a prior appeal. I appreciate the arguments to the contrary, but
the majority didn't change it, right?
that is correct. That we know that, but
the majority could have said the motions panel didn't know what it was talking about and could have done its own thing, right? So
and I appreciate that flexibility that this court can and will exercise. However, this court again did say, well, but we are going to hear it later. So it is somewhat of a mystery what that was. But when we go back to that order, if this court does decide that it's a non-final order, even as to the attorney, we can still look at the core argument about the fact that the judge had already referred this case to arbitration and therefore didn't even have jurisdiction to engage in this particular judicial exercise that he did. And we cited the case Arquette v. Butler from the 5th from 2014 about the fact that a 1540 may be filed any time because of the voidness of that. And it was a judgment on an order to show cause. The order to show cause was based upon an order to show cause for sanctions. The judge was looking at this as a sanction. The order, because of the arguments that, well, you can't sanction, you can only disqualify, says, okay, well, I guess I'm not going to sanction, but I am going to refer this to the bar, and I'm going to immediately, effective today, sever the relationship of attorney and client, when we now know that that's error. But we also know that there is a panoply of new information that we have found that would be very relevant to that information, the kind of information that needs to come to light. And I'd mentioned earlier that the phrase, the truth will out. And if we are doing what justice requires, then there must be an avenue. I am hopeful that we do not have to have a Moyer 3. It would be incredible for this insular issue to need that additional bootstrapping to get before this court for that final review. And that's why I urge this court not to find that the sanction order as it was non-final, even as to the attorney. The Shook v. Alter decision makes clear that where no further judicial action is necessary for that non-party, in that case an attorney, that's the reason that it's a final order. Here, there is no further judicial action that was necessary as to Mr. Roy. It is a final order as to Mr. Roy, whether you call it a sanction, whether you call it a disqualification, even if there's another avenue to go under. That other avenue is for the clients. We believe that this court does have the jurisdiction, and in the interest of justice and following the In re Decker decision, should utilize that jurisdiction to reverse and at a minimum require the lower court to rehear this and give an evidentiary hearing to allow that testimony to come forward, which would finally let the truth out. Thank you, Your Honor.
Let me just real quick. You alluded to Moyer 3, and I'm inferring from that the trial judge would enter a final judgment related to the arbitration award that was, I guess, mentioned inferentially here by both of you. So that would be the appeal. That would be Moyer 3. Just contextually, you're not talking about Moyer 3, go to the Supreme Court if you don't like that. You're talking about Moyer 3 is here.
No
court, if you're unhappy,
to go to Tallahassee, Your Honors, if that can be avoided. That Moyer 3 does, in fact,
I'm sure we won't hold that against you. The Tallahassee people won't hold that against you.
I'll be happy to get there on my oral argument that I have 2 hours from now. This
Okay.
one, I would like to avoid that trip.
All right. Thank you, counsel.
Thank
All
you.
right. Thank you for the argument. Interesting discussions today about jurisdiction. All right. We will now stand adjourned.
Thank you, Your Honors.
You gonna